Good morning, good afternoon, and good evening to all of our attendees around the world. Welcome, everyone. Thank you for joining us for today's webinar hosted by KCAB International LA office. My name is Sunna Lee. I'm representative of KCAB International LA office. I will be moderator for this webinar. This webinar is co-hosted by ADR Services in Irvine, California, LimNexus LLP in San Francisco, California, and law firm Dasan in Suwon, Korea. Also, we have co-hosting law schools, which are Handong International Law School in Pohang, Korea, and Trinity Law School in Santa Ana, California. For this webinar, we have great attorney presenters. Hello. I will introduce each of them before starting its presentation. Today, we are going to discuss arbitration between Korea and United States. It will be about 1 hour webinar. After the presentations, we are going to have Q&A sessions briefly for about 10 to 15 minutes. During the webinar, you may put your questions on the webinar dashboard. After all the presentations, our panelists will answer the questions. This webinar will discuss various international arbitration issues. I think it will be very helpful to legal counsels and corporations dealing with arbitration matters. All of our panelists have outstanding and extensive experiences in their professional fields. Without further ado, let's go ahead and start it. Now, I'm gonna introduce our first speaker, Hyun Lim. Sue is Secretary General at KCAB International in Seoul. She is a licensed attorney in Korea and New York. She was partner at Beck Kim & Lee in Seoul, and she specializes in international arbitration involving complicated cases. She's gonna present conducting arbitration proceedings during the pandemic and measures by the KCAB. She will give us welcome remarks and presentation. Secretary General.
Thank you, Sana, and hi, everyone. It's good to take part of this seminar. As Secretary General of KCAB International, I would like to welcome you again into this webinar. Just like Sana, our LA representative for KCAB mentioned, today we'll give you presentations on a number of legal and procedural issues in international arbitration involving US and Korean parties. So of the various issues that we prepared for you today, I will share the experience of KCAB regarding virtual and remote hearings, which we had plenty since the start of the COVID-19 pandemic. But before that, I should give you a really quick introduction to KCAB International, which is the international arm of the Korean Commercial Arbitration Board. And after that, I'll share you what we have seen as to the trends and the practices of virtual hearings held in international arbitration. So so we're now to the next slide. Thank you. So there are many arbitration institutions around the world, but there is only one in Korea, and that is the Korean Commercial Arbitration Board, better known by its acronym of KCAB. First, a word on KCAB's origins and developments. It was established in 1966 as part of the Korean government's policy of encouraging arbitration as means of resolving commercial and claim disputes. In the beginning, it was usually largely small domestic cases that involved Korean arbitrators. Many times the arbitrator was not a lawyer, and it was conducted in Korean language. But as the Korean economy grew and became more international, more Korean companies went overseas, there was an increased need of the capacity to resolve and assist the resolution of international arbitration cases. And in response to that, there were various measures since 1999. For example, there was an amendment of the Korean Arbitration Act. The KCAB amended or introduced a separate set of rules called the KCAB International Arbitration Rules, which functioned entirely differently from the domestic rules. And in 2011, there was another amendment to the arbitration rules in response to the users' feedback. And more recently, in 2016, we did another revision to the international arbitration rules. The revisions were usually to increase the efficiency of the procedure and to reflect the modern practices of those days. Next slide, please. Right. So in 2018, and this was about 2 years after the most recent amendment to the arbitration rules, the international arm of KCAB International was established. As I mentioned, even starting 2007, there was a separate international arbitration rule that was dedicated only to international arbitration. But because there was an increasing number of international arbitration disputes being filed in KCAB International, these users were becoming more diverse, so were the council, and of course the overall, the global community was becoming more sophisticated in terms of their expectations of how arbitration should be conducted. What KCAB did was it revamped an entire new structure for the international arm and created a new secretariat. I joined after KCAB International was established, and all the case counsel that are working with me also joined after the international arm was established. We took special care to make sure that everybody who is now involved in KCAB International, including people like Sana, who's our LA representative, were people who were qualified as lawyers, have experience with professional services, and who are very attuned to the demands and needs of international users. And of course, one of our most important focus is to make sure that the arbitrators are people who are perceived as being neutral as in their nationality, their interest in the industry, and people who are just renowned and known for their professionalism in terms of their legal skills. And of course, we have many arbitrators listed in our panel of arbitrators who are US lawyers who have close connections to Korea, but still have a reputation that will give them the trust of both parties, whether they're from the US or from Korea. Next slide, please. So the case statistics, we are considered to be one of the very busy arbitration institutions around the world. In fact, of course, there's a there are very notable outliers, such as the American Arbitration Association. I think they have at least 10,000 cases a year. And then there's the Chinese arbitration institutions, which have very similar numbers. But apart from that, if we start thinking of the arbitration institutions such as the ICC or the one in Singapore, the one in London, Korea actually, the KCAB actually has quite a high number of case statistics. We are seeing a steady increase of numbers, and I think the recent numbers was 443 for last year, and I'm happy to say that our numbers are increasing on a similar speed for 2020, despite the difficulties in the economy due to the pandemic. Next slide, please. The parties that file cases to the KCAB or are the receiving end of the files, the nationalities are very diverse. Not surprisingly, the highest single number of nationality is from the US. The second runner-up, very close, one is China, and I think that reflects the current situation in the Korean economy, where most of our trade volume comes from these two jurisdictions. A jurisdiction that is increasingly coming up into the ranks is Vietnam. Obviously, we have a lot of Korean investments into Vietnam, and a lot of Vietnamese imports from Korea to Vietnam. So that, with the increased number of trade, there's also a proportional increase of disputes. And since we also have a Hanoi office, a KCAB office in Hanoi, we are doing our best to assist the parties that are involved in disputes that have KCAB, the KCAB rules in their dispute resolution clause. And then the rest of the nationalities, they're the usual ones that we see a lot in the Korean economy or Korean current landscape. Next slide, please. Yes, so now we're coming to the area of hearing facilities. We are very proud to say that we have a very state-of-the-art hearing facility right at the center of Seoul. It's right at the Gangnam district. And it's it was entirely revamped in 2018. Now we continue upgrading its systems, particularly the IT infrastructure that is needed for conducting arbitration hearings. A good thing about this is that as long as you are in that facility for arbitration hearings conducted under the auspices of the KCAB International rules, there is no separate fee for using the hearing room. But of course, we also welcome different types of dispute resolutions. Like we host numerous ICC arbitration cases. There is a continuous stream of Singapore SIC, the Singapore Center, and the HKIC Hong Kong Center's case as well. And we're open to hosting depositions of litigations outside of Korea, since the key feature of this hearing facility is that we take confidentiality and support very we put that in as our priority. So if people are in a situation where they want a very quiet and very private place to conduct what they need to do for their dispute resolution, then we are there to assist. So next slide, please. Yes, and finally, I get to the main point of my presentation, but looking at the clock, I don't have that much of a time, so I'll just go over the very quick key points that I would like to share. So Korea, even the Korean litigation courts and arbitration, of course, we have always been very open about allowing remote hearings. This might partly be due to the legal tradition that there isn't such a large emphasis on live, spontaneous oral advocacy that you would more see in the Anglo-American legal tradition. But instead, there's a lot of more documents, heavy, more inquisitorial mode by the arbitrators or the judges, and not so much witness testimony in the tradition. Of course, we always support the full-fledged international type of arbitrations where we have openings and we have witness testimony and whatnot, but there has been more a larger variety of how you deal with disputes, and that also includes the more traditional Korean way as well. With the advent of the pandemic, there has been quite a number of changes, improvements mostly at the KCAB's hearing facilities. We've took this opportunity to revamp and upgrade all our IT systems, everything from the 360-degree camera that shows you a panoramic view of the hearing room. Our the microphones have been upgraded, the screens have been upgraded, and of course, because Korea still has never gone through a proper lockdown, everybody who are willing to come to the hearing facilities, they do come. So we've set all these protective gears around the tables and desks of people so that there is minimum risk of contact and minimal risk of spreading any possible diseases. Another thing we did, not just the hardware, but also the software part of our support for remote, is that we have helped create these guidelines or protocols about how to conduct video conferencing. Video conferencing is just basically a hearing where everybody expects a fair share of their opportunity to present their case, but at the same time has to be confidential, at least in the international arbitration context. So we've set up a protocol, and I think we're one of the earliest ones among all the various institutions that we give guidelines to tribunal members and to parties on how to conduct a efficient but a very fair arbitration or video conferencing hearing. And I'm very happy to say it's been used by a lot of international tribunals. I think the Vienna Center actually puts up our protocol as their go-to guidelines. It's a very down-to-earth, it's a very very reasonable and useful, easy to use protocol that we helped create and are actually trying to improve, and will hopefully have a second version sometime the end of this year. We also have our usual quarantine, sanitary measures, the thermal cameras, all the sanitization occurs several times a day. We assist people with their quarantine situation, and all these things that help arbitration go on as close as possible to normal, even in these difficult times. I am one of those people who are very confident that this COVID-19 situation will go away, hopefully sooner than later. But even after everybody's free to move around, I think the value that we get in terms of cost saving and efficiency through the video and virtual remote video conferencing or hearings is something that we shouldn't lose even after the situation has been settled, and hopefully we will see more of it. Just in May this year, we had a very large case involving US parties and a Korean party, where the U.S. party, for obvious reasons, were not able to travel to Korea. We assisted them in all possible measures so that the hearing could go on as scheduled. The U.S. party expressed great satisfaction to how the virtual hearing was conducted, and it went on smoothly, so that each party would have an outcome that they could carry on for their next steps in terms of protecting their rights. So businesses as usual. We have different models of how to conduct the same business in response to the current situation, but I think it's a manageable situation, and I think we'll see more of these remote virtual hearings. So that's it for now. I've probably used too much of my time, and I'll be happy to answer questions after the other speakers have shared their presentation. Thank you for listening.
Okay, thank you for the presentation. Now I'm going to introduce Ryul Kim and Joo-hee Lee. Mr. Ryul Kim is neutral at ADR Services located in Irvine, California, and he specializes in mediation and arbitration. Also, he is professor at Trinity Law School. He always supports Korean community and legal professionals in California. And Ms. Joo-hee Lee is Korean attorney at law firm Dasa, located in Suwon, Korea. And she specializes in civil litigation and public interest. Professor Kim is going to present the recognition and enforcement of foreign arbitral awards in Korea. This topic will mainly focus on the US matters. Professor?
Thank you very much, Sonali, for your generous and kind introduction. And good morning to my friends and audience in Korea, and also good morning and good afternoon and good evening to everyone here in the US. Well, 2015, I have published a book. It's not a book, actually, an article on today's topic, how to enforce US arbitral awards in Korea. And I'd like to just share with you a screen right now. As you see on this screen, there's one article which was published by Pepperdine Dispute Resolution Journal in 2015. The Korean judge, Jang Young-bom, and I have worked on this article, which is the same topic as today we now deal with, how to enforce US arbitral awards in Korea. And this has been published in 2015 and covered like the 1999 New Arbitration Act of Korea. And there has been a subsequent amendment to New Arbitration Act of Korea. So now I work with attorney Joo-hee Lee with Dasan Law Firm, so that we can revise and publish a new edition next year. And we hope that we're going to cover 2016 and 2020 amendment to New Arbitration Act, and also the recent Korean court decision. And I have only 15 minutes allocated, so I cannot really cover today's topic in more meaningful way than this article already published. And if you are interested in more information, I strongly suggest and recommend to download this article from internet. This is all free, and just Google with the keywords with the recognition and enforcement of foreign arbitral awards in Korea. Then you can download free version as well. Also, if you have access to LimNexus, also you can download the same article. Suppose you're a US lawyer who just won big arbitration award. If you cannot really reduce or convert your arbitral award to US dollars, it's going to be just remain as a piece of paper. So your question is, how am I going to enforce US arbitral award in Korea if the losing party, the party who lost US arbitration, has no asset here in US? Then the only option you can explore is change your arbitral award in Korea. Then where's the answer you can find? The answer is found the New York Convention under the laws of Korea. The New York Convention is one of the multinational treaties. 167 countries worldwide signed and adopted as part of their domestic laws. And Korea has adopted this treaty in 1973. So took effect as a domestic law of Korea in 1973. So if you understand this UN convention and also how this UN convention is operated under Korean law, then you can find a way how to enforce your arbitral awards in Korea. And the good news is this: US arbitral awards are more readily and more easily enforced by the Korean court than US court judgments. So you have to start with 1999 New Arbitration Act in Korea, which actually are designed to effectuate the terms of New York conventions. So even though there are some amendments to 1999 Arbitration Act, this 1999 New Arbitration Act in Korea remains as main statutes which controls how to enforce US arbitral awards in Korea. And also, especially between US and Korea, there is bilateral treaty, which is often known as COROS FTA. Under this bilateral treaty, private investors may seek enforcement of arbitral awards under New York Convention as well. So I just copy and like to show you a portion of the Korean statutes, which is Article 39, providing the ground for enforcing New York Convention as part of Korean domestic law. As you see this picture depicting judges in Korean Supreme Court, it's going to be eventually the Korean courts who is going to recognize and enforce U.S. arbitral awards. And luckily, over the last 2 or 3 decades, the Korean courts have taken the approach pro-enforcement judicial policy. And it's really coincide with the new Arbitration Act of 1999, and the Korean courts have become really friendly already. And after 2000 amendment, the Korean courts is showing friendlier approach to enforcing U.S. arbitral awards in Korea as well. And also there have been recent amendment to Arbitration Act, which took place 2016 and 2020. And under these new amendments, Korean courts could be said one of the most friendliest of jurisdictions in the world. The most frequent scenarios you see is you have arbitration taking place in US, and the losers, the parties who lost in US arbitration, don't have any assets in US, however, have some assets in Korea. Then the winning parties is going to go after the losing party in Korea. Then the losing defendants try to, but unsuccessfully objected enforcement in Korean courts. And usually they try to fight back on the ground, the very, very limited grounds acknowledged under New York Convention, Article 5.1. And there are 7 grounds, very, very limited and specific grounds where the courts are allowed to refuse. And also there are 2 grounds under New York Convention, Article 5 and 2, arbitrability and public policy. And you see over and over that the losing parties attempt to invoke some or all of these grounds, but have been really unsuccessful most of the times. And especially public policy has been raised over and over repeatedly by the losing party who objects the enforcement in Korea, have been really, did not help them at all. And we have like 4 cases which I'd like to discuss with you briefly if we have time. And the case number 1, well, if you look at this top part, this is the case involving a Texan arbitration award and has been heard in Incheon District Court. In Korea, District Court is like a trial court, the court of first instance. And in this case, there's a breach of contract and default arbitration award was rendered, and the defendant was individual who is Korean national. And the case was heard by American Arbitration Association, and the place of arbitration was Dallas, Texas, and Texas state law was applied. Here, the defendant in the Korean court argued that, hey, there's no arbitration agreement between defendant and 2, because the contract was between originally the plaintiff, a US resident, and a Korean corporation. And also, second argument was that there has been no damage, but the Korean court said, well, under the Texan law, there should have been valid arbitration agreement. And very interestingly, the Korean court was willing and able to review the state law of Texas to make decision on whether arbitration agreement existed under Texas law. And also with respect to second argument, there's no damage. And the Korean court said, well, under the New York Convention, the Korean court is not allowed to look into the merit of arbitral award. So that's not a good ground either. And the last argument the defendant raised is this: U.S. arbitration, just like a U.S. litigation, is too expensive for Korean residents to go to Texas and defend and participate. But the Korean court said, too bad, sorry, but since minimum procedural due process has been met, and we cannot refuse to enforce the judgment. So as long as the defendant was given a notice of arbitration, and then the Korean court is not allowed to refuse the enforcement. And we have another case here in the second case I like to discuss is where plaintiff was French corporation and defendant was Korean corporation. And the arbitral authority was Motion Picture Association of America, aka MPAA. And arbitration took place in Los Angeles, and the law applied was California state law. And here in this case, defendant lost US arbitration, and then the winning party, the French corporation, was trying to enforce the arbitral award in Korean court. And then the defendant raised the issue that MPAA is association, just trade association. So it's not the arbitral award should be refused, and there's no damage. And the Korean court said under New York Convention, well, it doesn't matter, it's a trade association, profit corporation, or non-profit corporation. So there's a limited ground for refusal. And also, even if there's no damage, the Korean court has no room to make decision or look into whether the damage award is good enough. So again, was refused. This is another interesting case. Here, non-parties, this case, in case number 3, the arbitrator in US with American Arbitration Association issued restraining order as a part of arbitral award against the non-parties. And then the non-party defendant in Korean court said, I'm not even a part of arbitration agreement. So the arbitrator in US has no jurisdiction or authority over non-party defendant. And enforcement of such arbitral award is a violation of public policy in Korea. But the Korean court said, no, even if that's the case, that's not one of those 7 grounds specially set forth on the New York Convention. So in this case, the Korean court enforced the arbitral award. Well, this is number 4 cases are very interesting and important because initially the plaintiff who won arbitration in US was not successful to enforce arbitral award in the Korean court. And the Korean court said, well, plaintiff, you won arbitration in US, but you failed to provide certified copies of arbitral award, and you failed to authenticate those documents showing that there has been a written arbitration agreement. So even if you won arbitration in US, the Korean court cannot enforce that arbitration agreement and also arbitral award. And this case went all the way to Korean Supreme Court, and it took 15 years almost. And finally, Korean Supreme Court held that, well, the lower court was wrong in applying that authentication and certification of documents too strictly. So the court, the Supreme Court then reversed the decision. Well, as my time is limited, the conclusion I like to make at this time is the Korean courts are really friendly, and there has been no single Korean case yet reported that US arbitral awards or any other foreign awards had not been enforced due to public policy ground. But still, unanswered and unresolved question is whether the Korean courts will enforce punitive damages or excessive general damages rendered by US arbitral authorities. Well, if you have any question later on, you can just pose your question. All right, thank you very much, and I really appreciate this opportunity.
Okay, thank you for the nice presentation. Now I'm going to introduce Mr. Grant Kim. He's partner at LimNexus in San Francisco, California. He specializes in international arbitration involving complex disputes. He regularly serves as an arbitrator under KCAB, ICC, ICDR, and AAA. He will present using federal court procedures to obtain a discovery from third parties in the US for using an arbitration in Korea or elsewhere in Asia. Grant?
Thank you, Sana. I'd like to thank the KCAB for organizing this. It's wonderful. I saw a long list of people who've logged in. I think some from the US, some from Korea. I know there's at least one from China and probably some other countries. So that's the magic of technology. Let me share my presentation here. So what I'm going to be talking about is a very special statute called 28 USC section 1782. And my basic point is it's a very powerful tool for the right case. And I'm going to explain why it's powerful and also what the right case is, because it's definitely not for every case. It can only be used in certain special cases. See, my screen is not advancing. Okay, I guess there's a lag. Okay, first question is, what is it? The statute's pretty simple. It says that you can apply to a US court to require a local resident to produce documents or to testify at deposition for use in a proceeding before a foreign or international tribunal. Fairly simple, but it's really unusual because what it means is you file a case in a US court to get discovery against somebody here, but it's not for use in the US case. It's for use in a case overseas. And in fact, there is really no US case. The purpose of the US case is solely to get discovery. So there are 3 conditions you have to meet, which I'll be discussing. And even if you meet those conditions, there are some discretionary factors where the court can limit or deny discovery based on those factors. And the last point I'm going to discuss is the issue of reciprocal discovery, which is quite important. So first, the statutory conditions. The application has to be made by an interested party. Generally speaking, that's a party to the foreign proceeding. So if, for example, you had a lawsuit or an arbitration in Korea, typically it would be the Korean party would be seeking discovery against the US party in the actually seeking discovery in the US. The second point is it has to be against a party who resides or is found in the local district. So for example, I have a case where our opponent, it was actually a third party we were seeking discovery against, who resides in Northern California. So we filed the case in the Northern District of California. Interestingly, it says resides or is found. Reside, of course, is somebody who is a resident. Is found could be somebody who's just passing by. If you happen to know somebody's, at the San Francisco airport and you can serve a subpoena while that person is there, you might be able to get them, although it's not definite. But the New York court, the Court of Appeals, Second Circuit, has held that's possible. And finally, it has to be for use in a proceeding in a foreign or international tribunal. Now, for use means it has to be relevant to the case. If it's not relevant, then why are you getting it? Interestingly, the case doesn't even have to be filed. If you're thinking of filing a case in Korea in the near future, you may be able to get discovery, which is amazing. You might think, well, gee, I'd like to file the case, but I don't know if I have enough evidence. You can seek it. It can't be something that's purely speculative, but if it's something reasonably contemplated, you may be able to get it. The last point is one I'm going to talk most about, which is you can definitely get it if it's a lawsuit in Korea, probably if it's a kind of adjudicative proceeding before an agency such as the Korean Fair Trade Commission or the Korean Patent Office. But there's a question as to whether you can get it for use in international arbitration. So if you have a KCAB arbitration in Seoul, can you get this? So I'm going to discuss that more. The question is, the statute says you can get it for use for a proceeding in front of a foreign or international tribunal. The question is, does foreign tribunal include a foreign arbitral tribunal? Now, to me, it seems on the face of the statute, of course it does. Now, however, there's an issue. All courts in the US have agreed that if it's an investment treaty dispute, an investment treaty arbitration, such as ICSID, it's a so-called state-sponsored arbitral tribunal, and you can get it. But 3 of the appellate courts, the 2nd, 5th, and 7th Circuit, said no. If it's so-called private international commercial arbitration, you can't get it. 2 circuits in very recent decisions within just the last year have said, nope, you can get it. That's the 4th Circuit and the 6th Circuit. Finally, the 9th Circuit, which covers California and much of the Western US, it's unclear. I actually was counsel in a case, and just 1 month ago, I argued that appeal. We're waiting for the decision. I'm hoping they rule in favor of our client, but I'm not sure. And our client had gotten a very lengthy decision, 28 pages from the district court, saying, yes, you can do it because that's what the statute says. And our case involved an arbitration in front of CTAC in Beijing, and we were able to get discovery against residents in California. So stay tuned. Very briefly, I'm not going to give you my whole argument. I'd be here a long time, but the basic arguments for why it applies and doesn't apply. Why it applies, you say the ordinary meaning. I mean, arbitral tribunal is a tribunal. So if it says it's in front of a foreign or international tribunal, that includes an arbitral tribunal. The argument to the contrary is, well, we're not quite so sure tribunal can mean that, but sometimes it just means a court. The response to that is in 1964 when this statute was amended. Before that, it actually said a foreign court, and foreign court was changed to foreign tribunal. So it can't just be a court because they changed it. Also, if you look at the legislative history, there was clearly an intent to promote the peaceful resolution of international commercial disputes. And of course, international arbitration is consistent with that. Finally, there's been a public policy argument made that if you allow this discovery, it would destroy the efficiency of arbitration, which has limited discovery. The contrary argument is, first of all, there are tools to limit it. Second, actually, the public policy is in favor of commercial arbitration. So if you're able to get this for foreign litigation, but not foreign arbitration, then foreign arbitration is basically now a second-class citizen. They don't have the same status. Now, as I mentioned, even if you meet the statutory conditions, there are discretionary issues you have to look at. First of all, you generally cannot, the first factor is, are you seeking discovery from a party to the foreign proceeding? So you got a KCAB arbitration in Korea, and the Korean party says, I want to get discovery against the US party, so they file this. Not certain, but very likely that will be denied, because the US Supreme Court said in a case called Intel that, look, if they're a party to the foreign tribunal, we don't have to worry about it because the foreign tribunal can deal with it. But if they're not a party, if they're a third party, the foreign tribunal can't do anything about it. So you're more likely to get to it. The second and third questions are quite related. It's whether the foreign tribunal is receptive to discovery and whether you're trying to circumvent foreign discovery. And there's actually a case involving the Korean Fair Trade Commission in Qualcomm, where Qualcomm wanted to get discovery through 1782, and the Korean Fair Trade Commission filed an amicus brief saying, we don't think it's necessary. And the court naturally declined it, because if the tribunal at issue says they don't want it, why would you grant it? But the mere fact that foreign discovery, as you know, US discovery is much broader, and Korea and most other countries much narrower. The mere fact that you couldn't get that discovery in Korea is not enough to deny it. The final question is whether discovery is unduly intrusive or burdensome. Generally speaking, courts will tend to be a little bit more stingy. They'll apply higher standard. They may allow it, but they may cut it back to what's really important. Reciprocal discovery. I know there was a question raised in the Q&A about, isn't 1782 kind of unfair to the US side? Because the foreign party can now get discovery against the US party, but how's the US party going to get it in return? And first of all, you generally can't get it against the US party itself, but you may be able to get it against a third party that's related to the US party, like a former majority shareholder, which was what was at issue in our case. The Chinese national who had signed the contract at issue was no longer the majority shareholder, was living in California. That's what we were seeking. So related to the other side, but not actually the other side. But an important point here is the court can say, yes, I will grant the discovery, but only if the foreign party also gives reciprocal discovery. Even when the US court would normally not have jurisdiction over the foreign court, the idea is the foreign party has now come here to the US and seeking discovery from a US party. Well, okay, now if you're here, it's only fair that if you get that discovery, the court may grant reciprocal discovery. Very quickly, there's some procedural issues. I won't go into detail, but basically the form of the discovery is you get a subpoena, which is issued for production of documents or deposition, typically ex parte. The respondent, after the subpoena is served, can object. The last question, what is the right case for this powerful tool? First of all, you really need it. I mean, although it's a very expedited and narrow proceeding, it costs money. So unless you really need the discovery, you shouldn't try it. And of course, it has to be discovery in terms of documents or depositions from somebody who's based in the US, either resides here or somebody you can find here. Generally speaking, you cannot get against your opponent in the litigation. At least you're much less likely to get it. So somebody who's like related but not actually a party. If it's a foreign court or administrative proceeding, it's easy, you can get it. But if it's a foreign arbitration, then you're going to have to see, is that allowed in that area? And as I mentioned, some courts, they say yes, some say no. The Ninth Circuit, we're still waiting to hear. A lot of the rest of the country, we're not sure. Eventually, this will get to the US Supreme Court. But for now, the last point, of course, is, are the benefits you're expecting to get from this discovery going to outweigh the risk that by filing the case, you're going to be opening yourself up to reciprocal discovery? So that's my basic outline. And I think many US litigators actually don't even know about this tool. And I don't know how many foreign lawyers know about it. So it's a very interesting thing, again, for the right case, because US discovery is quite strong. You can get documents, you can get depositions. That may be very helpful. So for the right case, it's a powerful tool. Thank you.
Okay, thank you for the excellent presentation. Now I'm going to introduce Eric G. Enlow. He is the Dean and Professor of Law at Handong International Law School in Pohang, Korea. He will present the recognition and enforcement of Korean arbitral awards in the United States. The topic will cover recent cases and issues. Dean?
Hi, hello. You can see me right now. There you go. Greetings from Pohang and Handong International Law School. It's a pleasure to be here today, and I thank my fellow participants in KCAB. I'm really going to talk today about sort of the counterpart to what my sometime colleague, Ryul Kim, attorney and professor, talked about. Except I'm going to do it on the US side, which is the question that we investigated here at the law school. We looked at all the reported cases that specifically considered motions to compel arbitration brought in US courts or to enforce arbitration awards, where the arbitration to be enforced or the award to be enforced was under the auspices of the KCAB or otherwise specific to Korea. So we're looking at cases where parties were bringing a motion to compel arbitration in Korea, or where there had already been an arbitration and they were seeking to enforce that award. And a long story short, although there are, depending on how you count them, around 25 cases specifically dealing with KCAB awards or motions to compel arbitration under the auspices of the KCAB, there are no cases reported, and this is parallel to what Attorney Kim noted in Korea. There are no cases reported where any specific grounds related to the KCAB or to Korea were offered in order to deny a motion to compel arbitration or to refuse to enforce arbitration. And so I think the conclusion that I would offer based on our review of all the published cases in the United States is that one can be very secure in invoking the KCAB as an arbitral forum or Korea as an arbitral forum and proceed in that way. Just very briefly, I won't belabor the point. Since the 1970s, the United States has been very much in favor, as a matter of congressional legislative policy, and even more so in the judiciary, of the use of international commercial arbitration. Of course, in 1970, the United States ratified the New York Convention and modified its existing Federal Arbitration Act, which can be found in Title IX of the U.S. Code, in order to implement that convention. And the provisions of the U.S. are very strong and very standard. And as Ryul Kim discussed, Korea has been very restrained in applying some of the liberties that the convention applies, by which one might refuse to compel or enforce arbitration. And so the United States courts have been very eager, in fact, to compel arbitration. I'm going to talk about a few different cases today. The first one I'd like to discuss is the very last case to discuss a Korean ground specifically. It was the last case in which parties argued that because the arbitration was to take place in Korea, that a motion to compel arbitration should be denied. And that's a case called Twi International versus Annam Pacific Corporation. And that was a case in 1996. And I'll post the exact citations later. There was a case in 1996 in the Federal District Court in California, the Northern District of California. And it was a fight over a distribution agreement. A U.S. corporation had gone to Korea to solicit a distributorship arrangement. And then there was an allegation of fraud, that there had been already set up an alternative distributor who was competing with the agreement. And so the U.S. corporation brought a lawsuit in a California court, and the Korean corporation, Annam Pacific, moved to compel arbitration. And the U.S. corporation resisted the motion to compel in a federal court after removal. And the argument was that it would be essentially a violation of due process to require them to go to Korea to arbitrate under the auspices of the Korean Commercial Arbitration Board. In fact, that's the exact ground that was offered, that the arbitration would take place in Korea under the rules of the Korean Arbitration Board was a ground for the refusal. This was proposed by the American party. And the court dispatched this argument very quickly, and it quoted the longstanding policy of the United States in support of international arbitration and a refusal to investigate the conditions of local arbitral authorities. This is a refusal that goes back through Mitsubishi and Moses Cone, all the way back to Shirk, which is a very early U.S. Supreme Court decision in 1974. But I'll just read you the language the court used because it's very strong. The court said, a parochial refusal by the courts of one country to enforce an international arbitration agreement would not only frustrate the purposes behind the FAA, but would invite unseemly and mutually destructive jockeying by the parties to denigrate various other countries. It would damage the fabric of international commerce and trade and imperil the willingness and ability of businessmen to enter into international commercial agreements. And the court concluded that the precepts cited by Shirk in 1974 are even stronger in 1996. They are particularly telling, though the court noted in this case where the parties have sought out a business opportunity in Korea. So to summarize that case, the court simply really dismissed the argument that there was anything inappropriate about the KCAB or arbitration in Korea, affirmed the bedrock policies of the New York Convention and the FAA, implementing it, and affirmed the strong policies of the United States to avoid the inappropriate inquiry into these kind of matters on the basis of that policy. There's a multitude of cases today affirming these same principles with even more brevity. Sungwoo Lee versus Imaging Incorporated, which is an unpublished Ninth Circuit opinion, is more typical. It's an enforcement action of 2008. Again, there was a challenge. The question was relating to Korea and the KCAB, and the court this time refused even to honor that, simply looking at Article 5 of the convention and the 7 limited grounds for refusing to enforce, noting that there was no basis in the arguments that had been made relating to Korea or the KCAB in any of those, and moving on through the argument. Just very briefly, because I know we want to have time for Q&A, there are two interesting cases that suggest questions for the practitioner. about Korea, and they're interesting. Really, the only recent cases where enforcement enforcement action of an arbitral award from Korea has been refused. There's a Western District of Washington case, a federal district court in the Western District of Washington called Korea Wheel versus JCA. And in that case, interestingly, and one of the more experienced practitioners before the Korean KCAB might answer this question. There was a motion to enforce an award from the KCAB, and the court found that the KCAB had split the issue. It was a case relating to damages arising from a breach of contract, and arbitration had been commenced to require payment of the invoices of a Korean company. And the U.S. company responded by saying that the quality of the goods that had been delivered justified a counterclaim action for damages. But the damages had not yet fully been calculated, and so quite reasonably, the arbitrators in that case issued an award on the invoices, but split off the action for the damages until the evidence could be produced to allow an ascertainment of the amount of the damages. So the Korean company went to the United States and asked to enforce the award on the invoices, and the court refused to enforce the award, did not refuse ultimately, but stayed the motion to enforce until the second part of the action could be complete. So that's a very rare case, actually, where there was a refusal to enforce an arbitration award. And the ground, again, was simply that the case had been split before the arbitrators, and a new case had been begun on the counterclaim, essentially. But that led to a refusal to enforce, better thought of as they stayed the application to enforce until the complete dual set of trials was done. Last issue, just because it's a very interesting case, and I'll conclude my remarks. Young versus Majestic Blue Fisheries, a Ninth Circuit case in 2017. And this case is a very romantic case. A sea sailor was rushed on board to try to save the captain of a tuna ship, and he and the captain went down with the ship. And the widow wanted to sue the Korean company that was involved. And the question arose in that case. The Korean company had a employment agreement with the engineer who perished on the ship, and it had an arbitration clause for arbitration with the KCAB. And the question was, could it be enforced against the widow as a non-signatory to the agreement, even though she was relying on the contract? And so there was an equitable estoppel ground in California state law. Even though she was a non-signatory, could the Korean company force her to arbitrate? The Ninth Circuit said no, it refused to compel arbitration. So again, this is one of a very small number of cases. But the ground that was offered there was the failure to gain her signature. And this was a circuit split. There was a circuit split that was just resolved this year. So this is why I mention it in a case called GE Energy versus, and I'm not sure how to pronounce this, Autocampo Stainless USA. The United States Supreme Court overturned the decision in Young versus Majestic, and it held that no, in fact, the New York Convention does not prohibit the application of state law doctrines to require the arbitration of non-signatories, despite some language in Article 2 of the convention that might suggest that. The court held that you were free to appeal to state law doctrines of contract, like equitable estoppel or alter ego or piercing the corporate veil, in order to include those who were otherwise relying on a contract with an arbitral clause in it, for their claim, to require them to arbitrate. So this is a very interesting thing. One of the few decisions refusing to enforce arbitration involving the KCAB or Korea, even though it was on a non-Korean ground, nothing specific to Korea or the KCAB, has been overturned by the U.S. Supreme Court. And it raises a lot of interesting issues. The United States Supreme Court, in deciding this, said, well, we're going to decide this, but we're not deciding today whose law should determine whether or not a non-party can be forced to decide. Should it be California? Should it be Korea? Should it be some other source of law? So this is a very interesting avenue of litigation that will open up with respect to non-signatory parties to arbitral agreements in the United States, and the use of arguments like equitable estoppel, alter ego, piercing doctrines to force them into arbitration. Well, again, just to summarize, our research showed that arbitration agreements and awards involving Korea have a perfect track record in the United States on grounds specific to the KCAB or Korea. So parties can proceed with great confidence in this area. Thank you for your attention.
Okay, thank you for the last presentation. Now we have a Q&A session briefly. First question is for Eric Enlow. The question is in regards to recognition of Korean arbitral awards in the United States. What aspects of Korean arbitration might compel parties to choose Korea over other countries as the seat of arbitration?
Yeah. There are a few other countries where questions about the conditions in the country from the U.S. perspective have led to courts being reluctant to enforce awards from those countries or to compel arbitration. It's usually a fairly extreme situation of war or a breakdown of legal order that does that. But I would say one reason to be confident in choosing Korea as an arbitral forum, or the KCAB itself to administer that arbitration, is that there is such a long track record in U.S. case law compelling arbitration in Korea and with the KCAB, and enforcing awards from the KCAB. One can be sure of finding precedents in the United States that make it a good forum. So I'd say that would be an excellent reason to consider Korea and the KCAB.
That's it. And then we have a question for Secretary General. The question is, how are potential privacy issues that may arise from the new online arbitration method?
Yes, thanks for the question. So the question, if I understood correctly, is what are the measures to ensure the confidentiality of the proceedings, despite the fact that the format was changed to virtual? This is largely a matter of the hardware that each institution would deploy. The system, the video conference system that is being used in Korea, in the KCAB center, the hearing center in Seoul, is cloud-based platform where it's one of those commercially available ones, but it's not the free type where the vulnerability to other outsiders are a concern. We take confidentiality quite seriously. So it's a cloud-based platform with the end-to-end encryption. Only the people who are specifically pre-cleared can access the hearing room. So it's not as free as you would have in the regular physical hearings. Like I've been doing these things for last 14, 15 years, and sometimes even if you're not, sometimes you just get pulled out that morning to go to a hearing room and assist, but that wouldn't happen in a virtual hearing because there's a bit of a protocol to ensure that only people who are involved are have access to the virtual hearing room. And if the parties agree and the tribunal orders, sometimes hearings are recorded, and even if you send the recordings around to people, we have a special route where only the the specific designees can receive it, and and ensure that the video and the audios are sent over in a very secure manner.
Okay, we have a question for Grant Kim. The question is whether U.S. companies operating abroad are disadvantaged by these U.S. courts making discovery in U.S. more available for international arbitration.
It's a good question. I have a two-part answer. The first part is actually when Congress amended that statute in 1964, if you look at the legislative history, they said, you know, we hope that this will actually encourage foreign countries to adopt similar laws, so it goes both ways. However, I don't know of any law like this that's been adopted in other countries. There are ways to get assistance if you're in US litigation and potentially arbitration as well. You may be able to get a court to issue letters rogatory through the Hague Convention process and assist with getting discovery overseas. But the other answer is actually no. If you're the US company and you're in litigation in Korea, for example, or arbitration, and the Korean party tries to get discovery here, first of all, it's not so easy to get it against the actual counterparty, because the court has discretion to say, wait a minute, no, this is really more for third-party discovery. Second, they still may try to get it from a related party. And if that happens, as I mentioned, there's the ability to say, well, okay, we're willing to give some discovery if the foreign party gives reciprocal discovery. So that's a fairness issue, which has been discussed, I think, by the Supreme Court in the landmark Intel decision. It says, you know, so this will kind of balance the playing field. So it is an issue, but there are ways to limit that. And let me just mention the CTAC arbitration I am involved with. We are actually representing the US party to get discovery against the former majority shareholder of the Chinese company who happens to live in California now. So there are cases where it may directly benefit the US party. You know, it's a very international world and people move all over.
Okay, we have a question for Professor Kim. The question is, does COVID-19 have any impact on the enforcement of foreign arbitral awards in Korea?
I think he's mute. It's on mute.
Professor, you are muted.
Can you hear me? Yeah. Well, we have to start off with New York Convention, Article 5.1. And under 5.1, there are only 7 grounds where enforcement can be refused. COVID-19 or pandemic or force majeure is not one of those 7 grounds. So my answer is unlikely, no impact.
Okay, we covered all the questions, and if you have any other questions, send us the email or call us. I'm gonna follow up with our attendees with wrap-up information from the webinar by email. Thank you, everyone. It was a pleasure being with you and all the attendees today. We hope all of you are safe and well. Thank you again for joining us today, and we'll see you next time. Thank you. Bye.
Thank you.